may also recall that asked you to introduce a motion to continue and a motion to secure that her Trabuzio's testimony, in particular in the criminal mischief case, because she's an obvious. I mean, she was the summoning officer in the they can't have the trial. I'm sorry, no, but I don't even think that they would ask to a judge to try that. But yeah, obviously, they want to proceed without her did express a desire, and Entwistle said that he wanted to proceed with the criminal mischief, and then in court and then later I wrote those motions, and so did you ever hear back anything? I mean, are those still pending? Have they been denied?
All right, you ready?
Sure.
So what happened, and some of this you can surely blame me. I got those documents. I can read those documents, but for some reason I can't download and print them. Like it's not. So what I did is I did a motion to continue, which was obviously acted on, right? Because we were set for a trial in December. Now, the motion to have her seen as a necessary witness, that is not something that's really in criminal procedure. Like, what I kind of told you about that is that's something that the trial judge would decide based off of the facts of what comes up.
Well, I asked the judge, but I asked the judge specifically at the end of that hearing. I said, so we should introduce a motion to secure her as a material witness and continue, and he said yes. So we had
continue, but
well, and I mean the at issue was her material. I'm quite sure that was part of that discussion as well.
That was my recollection is mostly that was a discussion with us, and that was saying, well, can we continue it based off of this witness not being available? Well, that would depend if that witness was seen as a material witness or not.
Okay. Do you think that might have been a good time to bring that up? Might have been a couple of months ago.
Well, we had it continued a couple months ago.
Right, but here's the thing. I asked you. I said, please introduce these motions, file these, and you said okay. You want me to do that? Okay. And so now a couple of months later, you're saying, well, no, that's not the kind of thing I want to introduce, and I'm very confused about why. Do you see why that might be confusing?
No, I would fully understand why you'd be more than confused, why you'd feel like, I was not honest with you, right? More
I don't know. I'm confused. I'm just telling you what the facts as I understand them, and I find them very confusing.
Yeah. So how I would try to explain it is that I tried to just and I know this part is not a very good excuse, right? I tried to just get those motions that you had. Do you use an Apple computer? And this isn't an excuse or anything, but when I was downloading the motions, for some reason I couldn't put them. I couldn't print them, put them in a document.
I don't know.
What I decided to do is we were like a week before or something supposed to be picking a jury. So I did a motion. I asked Entwistle, do you object with a motion to continue? Our rationale would be that we need this witness. We understand you might disagree. So without you agreeing whether that's a necessary witness or not, are you still okay with us continuing? That could be a battle later on. We just need to get this off of that. and he said that he did not object to continuing it off of that date. So I continued it. So the court agreed to continue it off that date from the motion. And the tricky part, and what I should have done is I should have told you that, and I'm fine with anything that you file, but I have a hard time coming up with a rationale, and this isn't the reason why I didn't file it. I think the reasons why I didn't file it would be threefold. It would be, number one, I couldn't just get the document off and file it. Number two, I focused on the first one to try to draft my own motion to try to get it off the date so that it would be off for the rationales that I think fit the court process better. And number three, I thought that it'd be like, would probably be neglect. Being, I thought I'd have time to then check in with you and do this and that, and then I didn't follow through with that. Saying, hey, I got it continued, can you just file that motion yourself because I can't get it to print, and I can't come up with a good rationale in my mind, because that's something that's normally done later on in the criminal procedure. That's normally done at the trial. You could call a witness who's on your list, who you've continued the case for, for that person to be, available. And then the judge says, no, I'm not letting you call that witness because the facts that have arose in the trial mean I don't think this person is a necessary witness. It's normally the trial judge who decides that, but that doesn't excuse the fact that this should have been something that I talked to you before.
Okay, look, here's the deal. I'm whatever, not too interested in redressing anybody, whatever. What I'm interested in is making sure that people do what they are supposed to do moving forward so that I can get a reasonably fair trial. Okay, now, and to that end, I have pretty much, as far as I understand, an inalienable right to relevant evidence. And I also have a right to compel witnesses. Now, the judge, the court, there's been different judges in various ways, that have been pretty deferential to the DA. I mean, they granted this continuance to the DA. I mean, they caught, for the 12-week medical thing. No issue there. So, asking that, that a case not proceed just until the DA complies with Rule 16. There's an outstanding order that he has been out of compliance with for months. And then a witness who is soon going to be available is available, just asking that these two fundamental rights of a defendant be respected before we go to trial does not seem like an unreasonable ask to me, especially since I was just noticed about this. And not only because I looked into it, I happened to ask and then follow up with you. So, I don't think that's much of an ask. So what can we do to make that happen? That's what I need to know, I guess. At this point, I mean, presumably, I don't know, bringing up on February 2nd, the discovery issues, that there's this outstanding rule non-compliance. The DA has been, because these cases are absurd, and they're the only way that they're going to win or get the most out of me, more than like, because I still don't think a lot of them will actually get, they're going to be ditched at the last minute, because they're weak beyond much reason. And I know there's always the chain. You never know how a jury's going to rule. I know, but These are pretty weak cases. These are our cases to lose.
You are very correct too, that these are not cases that would normally be brought.
So we need to make sure that I at least get a fair trial and the jury hears the whole story, right? And that's all I need. That's what I need. That's what I'm interested in. Okay, so how do we do that?